So I'll go on record by saying that, despite the SEC's involvement or enhanced involvement in recent days, I still believe that firmly that you can conduct ICOs within the United States and offer your token to United States residents, right? I think, there's a great deal of emphasis and there's a great deal of misinformation about Howey and how it's interpreted. Howey's a 1947 case. There's 200 some odd cases that follow it that redefine it, carve out exceptions, right? Amend it, reinterpret it, interpret it completely incorrectly, you name it, it's there. So, my argument is that to the extent that regulators want to rely on how we test, you should as well, right? And that's not just sort of a blind opinion from an attorney, but it's a realistic evaluation of how your token does or doesn't fit under that test of not only Howey, but as we say, it's progeny, right? The cases that follow. And that's necessary, right? I mean, I think that's relevant. And I think it's ultimately going to come to that. And I think, when you look at the scope of, SEC involvement today, it's actually pretty limited, right? As enforcement actions go, I think it's fairly limited. And, you don't see anything with the exception of Munchie, Dow, and some other ones that were just outright Ponzi schemes. You don't see any decided enforcement action. You see some sort of inquiries, which is fair, and I think it's right. I think, that's going to come, right? And I think it's important that there's this dialogue between regulator and issuer, so we can find, as an industry, negotiate or sort of help the regulator explain to where we get to the best sort of state possible, right, within the law. And I've long been of the argument that cryptocurrency really is more akin to a commodity than a security, right? And I think the CFTC, which claimed Bitcoin back in 2004, arguably is where this should land. Does it? No. I mean, the CFTC is a much smaller organization, doesn't have the resources, doesn't have the cachet. But I think when you look at, how this works, especially considering the fact that the CFTC has jurisdiction over Forex, right, currency exchange, that's really where this should fall. Okay, and you have some hybrids, right? Starting in the early 2000s, that's when you started getting, when you saw mortgage default swaps and these other sort of esoteric financial products. That's where you started getting these hybrids, which were both securities and commodities, or they started as securities and they became commodities, or vice versa, right? So, it's possible to be a hybrid. It's possible to be something new, and so I think the discussion is valid, right? And I think, it's changing, but, irrespective of the fact, I can appreciate the interest of the people who call me and my clients who say, we're not going to deal with the United States, right? We're not going to deal with the United States. We're just going to sell outside the United States. And I've been involved in plenty of ICOs that have done very well, not involving United States residents, which is pretty, it's pretty significant. I mean, hell, hey, it's a big market, right? It's the biggest in the world, but there's something to it. So this is one of 5 of the offshore ICO. Hopefully, it's a fairly constructive roadmap on how to do this and how to do this offshore. And I say offshore using sort of the bunk, bad attorney in the old tweed coat, looks like hot hell, and I mean, not that I agree, but looks like hot hell, and it looks like he rolled out of a resale shop. But out of an abundance of caution, let's say you're going offshore, right? I don't think you have to, but maybe you do, right? Maybe that's your option. Maybe that's the play, and for right now, maybe that's the safe harbor, right? Maybe that's the way you do it. So that said, how do you do it? The first step, right? The first step, obviously, where do you incorporate? I get it 3-4 times a day, and if you go back in a lot of my videos, I've talked about places that I like as an offshore jurisdiction, which I think are ideal for this. So let me update that and let me put some clarity on that, and that'll be step 1, and we'll go on from there. So first of all, the thing you have to imagine or know is that if you are going to sell a ICO and you're going to exclude U.S. residents, you don't have to, okay? You do not have to incorporate offshore. You can incorporate anywhere in the United States. You just can't sell necessarily to U.S. investors. And if that's your option, to not sell to U.S. investors, then you're taking advantage of what's called Regulation S. And Regulation S is an exemption from registration, right? Much like Reg D, but it does away with the qualifications related to accredited investor status and also the qualifications related to how you market a securities offering, right? So if you look at, like 506, right, the crowdfunding, 506C, the crowdfunding exemptions, which allowed you to sort of sell like in a very broad solicitation, right? Sit out in the corner with your PPM and, you could do that, right? You could always do that. But the problem with 506C is you were limited to accredited investors, right? And when I look at the scope of this SEC involvement, the focus seemingly has been on security tokens, right? Where people seemingly were doing what they said they were, that conceivably they think they should do, which is call it a security. And then B, deals where people sought to adhere to the tenets of Reg D but didn't need to, right? So where they said, well, hey, it's not a security, it's a utility token, but we're only going to sell to accredited investors. And I think that's the jurisdictional hook that allows the SEC to come in. So, I don't think it really helps you to sort of straddle the line like that. But the reality is this, like when you are doing a Reg S, right, which is pertains to non-U.S. residents being offered, you don't have to worry about any solicitation limitations. You don't have to worry about accredited, non-accredited. Okay. Your one prohibition is to not violate the anti-fraud provisions of the Exchange Act, which basically means don't lie, cheat, or steal. So, okay, try not to do that, but that's the concept. That's the concept. So you could be a Delaware corporation and you could live in Florida, right, and just conduct your offering outside the United States, right? And that is a Reg S, and that's totally exempt from registration. Now, what are some best practices as it relates to that? Well, obviously, you've got to put, some sort of IP tracker on your website. You have to be sure you know who's coming and who's out. Number two, I would restrict access altogether to U.S. investors, right, during the ICO period. After the fact, that's a different story for the second email. But during the pre-sale ICO period, just block it from U.S. investors. Redirect them to Disney.com. It doesn't matter. Just out of if you're gonna go that far, right, you're gonna go this far and say I'm gonna take out the largest market in the world because I'm doing it because I just want to be sure, well, then you might as well go all the way, right? So just block those IPs, okay? And then 3, when you get investors, you have to do like some two-step verification, right? Two-factor identity verification through a third party with like an attorney's reference, attorney or CPA's reference that confirms that, and also a suitability requirement, right? Who are these people? What do they make? What are they worth? Okay, you don't need to do it, but it's wildly important that you do it so you're not inadvertently taking U.S. residents who are either, are trying to back end you through either like shill investors or, corporations that are controlled by them, vice versa. So that's the first part. It doesn't actually require you, right? The offshore ICO doesn't require you to incorporate offshore. But if you're willing to do it, which I think there's some great advantages to do it. And if you're going to do it, you might as well do it. But again, take into consideration the fact that most of the time you're here, right? You are in the United States, right? You're not in my study, but you're in the United States. And as a result, your actions do matter, right? To an extent that you bring them in the United States. From a tax perspective, which I can't necessarily get into, it matters because money that you may earn is going to come back to the United States. So take in consideration that you're here. You're not like offshore man all of a sudden, but you're here, okay? But if you are going to go offshore, right, and I think it makes more sense to incorporate offshore, and I've said this before, I'm a big fan of Nevis, I'm a big fan of Belize, and I'm a big fan of the Cook Islands, okay? And I'll hit this up with some greater detail in a subsequent thing. But those are still my go-to places. Nevis is, I would say, crypto agnostic, right? Meaning it's not necessarily like welcome, but it's not necessarily frowned upon either. And the value is that through their offshore business corporation structures, what you conduct through that Nevis corporation is deemed to occur outside of Nevis. And that's what's important. I get a lot of calls about the Cayman Islands. I've set up maybe 50 funds in my lifetime. I get it, right? The optics are great. But, the optics don't necessarily give you what it is. For the $4,000 versus the $900 for Nevis, you don't get the same level of asset protection. You don't get the same level of privacy. you don't get the same tax advantages. You don't get the same treatment of judgments. I mean, you get a whole host of kind of issues that come with it that for the crypto community, I don't think really give you an advantage. If we were doing a hedge fund, be a different story, right? 90% of the world's hedge funds are there. There's a reason for that, right? There's a reason for that. I get that. But in the ICO context, you're not dealing with institutions for the most part. Admittedly, you're not dealing with wildly traditional finance experienced people, right? You're just not. You're dealing with crypto entrepreneurs who made a lot of money in crypto and are looking to do it. So the optics are less important, right? So again, I go back with, Nevis, Belize, Cook Islands, on a second tier, Panama, Vanuatu, Seychelles, Mauritius, great places as well. But that's my thing. Now, people ask me about like Gibraltar. Okay. People ask me about Estonia. Well, they're crypto friendly. Yes, they are, but it's window dressing, right? It's all window dressing. The reality about like Gibraltar is Gibraltar's actually passed a cryptocurrency statute, right? So you can go there and you can incorporate, but even if you're going to operate extra jurisdictionally, right, outside of Gibraltar, you still have to register and comply with their own domestic cryptocurrency law. Whereas you don't have to do that anywhere else in the world. Same with Estonia. So why would you go there, right? Why would you go to these countries that offer you no asset protection, offer you really very minimal to no tax advantages, right? Aren't necessarily easy to operate in. And then you have to comply with a law that you otherwise wouldn't even have to. You wouldn't even have to comply with the law if you're in the United States, right? Right now, if you want to do an ICO, again, like I said, you want to do an ICO and you want to be a domestic corporation and just deal with outside the United States, there are no regulatory filings to make. There's there's registration qualification, none of it. Even to do a Reg D, all you have to do is file a Form D. That's easy. That's 10 minutes, right? Why would you go to Gibraltar and then have to do a filing in Gibraltar or Estonia, right? How would you even do it? Why would you do it? Same with Switzerland, right? Switzerland, it purports to be, it fancies itself to be everything in the world, but the reality is it's not. I mean, do you want to get audited, right? Have to do an audited financial statement for your corporation every year? Do you want to have to actually prove $50,000 in net capital? Why would you want to do any of that? Why would you want to pay all that money? It doesn't give you any of the advantages, right? It doesn't give you any of the advantages. And if you're in the United States, Nevis is a short flight, and guess what? It's 20 degrees here. It's a great place to go. Same with Belize. Beautiful place, right? Cook Islands, I don't know where it is, but I know it's hard to get to, and there's other reasons for that. But my reality is these places that advertise tend not to be what they are, right? So I stick to the two concepts, right? Where to start. If you have operations, if you are an established company with operations and starting like offshore is, create some sort of operational issue, right? Because you've got a track record, you've got assets, you've got people here, and you have to start something over here offshore. You don't need to do it, right? You don't need to do it, and it may not be worth doing considering the fact that you already are established in the United States. In the alternative, where you're earlier stage or, you're working on development and maybe you're just right past MVP or before MVP, well, you still have the flexibility, right? So, at a minimum, either just incorporate and domicile offshore, or if you've got some IP, create that offshore entity, do a license between the domestic entity and the offshore entity of the IP, and then have that company be the ICO issuer. What's really, really important, though, okay, is that the network or platform, right, that the tokens are to be used on, right, okay, or issued from in the context of a security, they have to be linked with the entity that owns the rights to that platform, right? You don't want to create this sort of separate scenario where party A is, issuing tokens, but party B owns the license on which those tokens are useful, right? I think they need to coax, right? They need to be one and the same, because that creates some liability issues, and it also kind of creates some lack of clarity as it relates to what you're really selling, right? Especially if you're a stock corporation, and you do have to be cognizant of securities laws in different countries, depending on what countries you do attack. So, that's part one. Much more to come. We'll get in depth next time. I'll talk about licensure. Get a ton of requests about best places to set up exchanges if I need like a money transmitter license, or that's appertinent to my ICO, or even securities dealer licenses, and like, is there a place where we can get like a Forex or securities dealer license that can deal with crypto? So I'll hit that up in part 2 tomorrow. But in the meantime, go back to lay the groundwork rather, as to the offshore ICO. So hit me up, bitcoin-lawyer.org, email at the bottom of the video here, and I'll talk to you later. I'm Adam Tracy. Cheers.